Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Kill.
Hey, Mike, how are you?
I'm fine, thanks. Thank you, Sam, for coming in much earlier than normal. For those of you out there, it's still dark outside. Okay, so today, Sam, we are going to do this is one of the statutes in the Davis-Sterling Act that I actually like a lot. And I don't know why, I just do. But we're going to discuss one particular statute, Civil Code 4515. Now, I'll let you guys look that up if anybody that's interested. But 4515, in general, it's kind of like a two-sided coin. It provides two sets of rights to homeowners that are closely related, but different. And we're going to discuss both sides of that coin. Okay? On the first side, 4515 protects a homeowner's right to criticize, even very harshly, their boards for work done on behalf of the HOA online, for example, social media or through email, stuff like that.
Right.
Notwithstanding any provision in the governing documents that would otherwise seek to prohibit you from disparaging your board.
Yeah.
That's one side. All provisions in any set of governing documents that purport to do that are void as a matter of law because of Civil Code 4515, which actually went into being because of provisions like that, by the way.
Exactly.
And then the other side of the 4515 coin is it also guarantees homeowners the rights to utilize common areas for certain things, which we'll get into in a few minutes. Those two sets of rights, all found in that statute, are what we're talking about today. And I like this. Now, how did this come to my mind? Well, I was looking at multiple topics to write about, as I do, because I try to publish a few times a week. You can find all of my published works on our website under the Libraries tab. Fact sheets, there are over 200 and counting. Articles, much fewer, but I would go to fact sheets. Articles, I don't really write anymore. I just do fact sheets. That's what I call my current articles, is fact sheets. And I read an article online on a very well-known online program, I guess software, or an online website, a news website on a platform for real estate-related issues. And in that article, the managing partner of a very, very well-known law firm in South Orange County, who probably bills in excess of $1,000 an hour, made some statements which were just 100% bald-faced wrong, displaying a staggering ignorance of the Davis-Sterling Act, notwithstanding the fact that this guy hypes himself as a expert litigator in real estate and business issues. Well, he might be, but he certainly doesn't know the Davis-Sterling Act very well, because what he basically said, and there was multiple quotes on this, but what he basically said was that homeowners who disparage their boards online or in social media could find themselves subject to discipline if there are governing document provisions that prevent that sort of commentary or disparagement by a homeowner. It's just wrong. So I wrote a fact sheet on that. I will put a link to that fact sheet, which was in, about a month ago in July, and the one I wrote just a couple of days ago. I'll put links to both of those in the description. I urge everybody listening to find those. I'll put links. Go read those. They're not that long, and you'll understand a lot more about what we're talking about today, because we're only going to cover this briefly. But that's what got me started on this. That was the article a month ago. Then what prompted me to write the article a few days ago was something else I read. It wasn't a news article or anything, but something else I read where an HOA was, it was a comment from one of our YouTube listeners. And their HOA was preventing them from using the having homeowners meet and use the clubhouse unless they agreed, by the way, to discuss a recall situation, unless they agreed to pay a deposit and get insurance for that event, both of which are illegal. So let's start with that side first.
Okay.
4515 protects homeowners from, or gives homeowners the absolute right to utilize common areas, a clubhouse, the pool area, a picnic area, whatever your HOA might have,
right,
to meet with fellow homeowners or to invite outsiders,
right,
to come in and speak about any issues related to what?
To HOA matters, governance, things like discussing special assessments, construction projects, could be matters of concern regarding a public office.
Or well, let's stay with HOA matters.
Yeah.
It could be recall elections. It could be elections in general. It could be to complain about how badly the board's doing,
right,
whether there's financial malfeasance or breach of it. All the things that you might want to do to criticize your board. You have an absolute right to meet with fellow homeowners,
right,
in the common area, somewhere like a clubhouse. We'll use that as our example, right? And to invite an attorney or anybody from the outside, right?
like a town hall, essentially.
Yeah. You can invite an attorney, you can invite a contractor, you can invite an accountant, anybody you want from the outside to come in and speak to fellow homeowners. Okay, so that's HOA governance. What else do they have a right to use those spaces to discuss and bring outsiders in for?
Well, I mean, you mentioned the recall. You mentioned
those are we already covered all the HOA stuff.
Right.
What about non-HOA stuff?
Well, non-HOA stuff would be things pertaining to public office, legislation. Let's say,
give me examples of each. So, federal elections, state elections.
Okay, sure. Federal elections, state elections, where you may have a matter of public interest. You're having a speaker come in to provide further detail regarding those proposed bills being passed, for instance. Referendums,
yeah.
Exactly. There could be a campaign element to it, canvassing.
You could have somebody that's running for office come in and talk to everybody about why they should vote for that person.
Sure.
You brought up legislation. You can talk about pending legislation. Let's say you get wind of a new law that's being considered, hasn't been signed yet. You can try to organize homeowners to, for a petition, let's say, to send it to the legislature.
Correct.
You can discuss other issues of public interest that relate to just matters that pertain to, us as citizens, I guess, right?
Exactly.
Those are all protected, all of those. And the statute is very clear. HOAs cannot charge a fee or require a security deposit, nor can they require you to obtain insurance to cover any potential injuries or everything that happens at that event.
Right.
They cannot do that.
Yeah.
Now, that's a stark difference from a private use by somebody of that same common area. For example, I want to utilize our clubhouse for a wedding reception or for a birthday, or for somebody's retirement party,
graduation party, any of those.
Where I'm choosing to invite either some members of the HOA or outsiders to come in.
Sure.
In those cases, I can be charged a reasonable fee as long as it's to cover actual costs incurred by the HOA. I can be asked to put a security deposit down in case I mess it up or don't clean it properly. And I could be required to obtain insurance for that event.
Absolutely.
Or even security, to make sure that things are being taken care of. That is perfectly legal, perfectly acceptable. That those private events don't fall under 4515.
Right.
We're talking about events about governance of the HOA or of public interest like legislation, elections, candidacies, that sort of thing. Okay? That's one side of 4515. Anything you want to add on that side?
Just the one caveat that, and I think we touched on this indirectly, commercial purposes. So anything that's of a commercial nature that is exempt from the protected element under 4515, and by extension, private parties, private events, where there may be a commercial spin or angle to it.
Let's say I'm a real estate agent and I want to invite prospective home sellers. Saying, why should you guys use me if you put your house up for sale? And I want to invite members of the HOA in. That's a private event.
And one more addition. If you have a predominantly social gathering, the ones we itemized, enumerated, weddings, graduation parties, birthday parties, etc.
I call them private events.
And then you incorporate, let's say, a single reference to a matter of, let's say, membership interest pertaining to the HOA. That would not qualify under the protected category.
That's more of an end. So people have tried to do an end run around the statute by saying, well, while we're at our wedding party or while we're at this bachelor party or while we're at this retirement party, we're going to talk about upcoming HOA issues. That doesn't rescue it. It's a private event.
Exactly.
Private events are exempt from 4515. We're talking about those other issues where people want to talk about, the purpose of the meeting is to discuss the things we mentioned or to bring in outsiders to discuss the things we mentioned.
Absolutely.
Now, that's one side. the flip side of 4515, or maybe not the flip side, but the additional side of 4515, which was in the which I discussed in my fact sheet from July, was this issue about these provisions in governing documents that basically prohibit disparagement. Now, a lot of people that see that sort of thing say, First Amendment, it violates First Amendment. I have free speech rights. Well, although HOAs are quasi governmental in some respects, remember the First Amendment really applies to the government. Okay? First Amendment rights don't naturally or automatically attach to HOA activities at all, unless there's a law that says it does. This law does in that sense. Okay? But in the absence of that, the declaration of I have a First Amendment right doesn't really qualify for a private organization like
no state actor, right?
Okay. That being said, you have the statute. The statute came into being several years ago, not that long ago, maybe
2022.
Yeah. So 4 or 5 years ago, right?
Well, the underlying 4515 was in 2018.
But this aspect,
the amendment was
this aspect came in just a few years ago.
Exactly.
And it came in as a result of provisions like the one we're going to talk about. There are documents, I wouldn't say most, I would say a good number. A lot of HOAs have a provision somewhere, whether it's in the rules or their CC&Rs, usually the rules, that prohibit, they're very broadly worded, and they prohibit disparagement. They're called non-disparagement provisions. And disparaging, of course, is a very broad term that means not just any old criticism, but also the kind of criticism which would also be illegal, like defamation, which we'll get to in a sec. Okay? Those provisions are void as a matter of law once 4 or 5 years ago, whatever, once the amended 4515 came into effect. Those became moot, void. They are of no power. Any lawyer or anybody else that tells you that a non-disparagement clause in your governing documents is enforceable is ignorant of the law. It is wrong. You can disparage the heck, even harshly, your HOA or any individual director or directors on social media or on the internet as much as you want. And they can't do a damn thing about it. Now, there is a line. Tell me about the line and break it down into illegal, civilly, and illegal criminally.
Yeah, well, the clear public policy to allow criticism, disparagement, it was very deliberate because of the proliferation of social media and how harshly the HOAs were coming down on policing and regulating all of this. So that was very deliberate, and this is why we had the amendment in 2022.
We had cases where people were actually fined. People were actually fined for criticizing their HOA and saying that the board didn't know what they were doing, that the board was engaging in financial shenanigans that were very suspect. People were getting fined for that, and then this law passed.
And the HOAs are being creative in terms of promulgating these rules and putting them kind of within proximity of the nuisance provisions and things of that nature. So in terms of the more narrow element, in terms of the defamation, where this crosses into defamation, is where you knowingly, promulgate false statements or attribute.
It doesn't have to be knowing. It just has to be false.
Well, false, yeah, but knowledge obviously factors in too, in terms of the intent and being malicious and things of that nature. So when it's something of that nature, that's a more narrow element that exceeds or goes beyond mere criticism.
Well, I agree with 98% of what you said.
Okay.
The only 2% I disagree with is because members of a board typically here are not considered public personalities or public figures. You don't have to prove. I don't think you have to prove malice, or do I have that reversed? When you're all right, so let's go with defamation for a second. Defamation can be either written or oral. In the case of social media, it's written, so that would be a libel, not slander. Slander is oral, libel's written. Okay, the number one thing is it has to be a lie. It has to be false.
Right.
Okay, because you've heard the old adage, truth is the best defense. Right. Truth is an ultimate absolute defense to a defamatory claim. You can't be guilty of defamation if what you said was true.
Correct.
You can only be guilty of defamation if it's false.
Exactly.
Okay? Now, you are not protected by 4515 to utter defamatory statements.
Right.
You're not. If you defame somebody, they can take legal action against you. They being the board as a whole or an individual director that's been defamed.
Right.
They have a right to take legal action. Okay? We won't get into anti-slaps. We won't get into the hills, the hoops you have to jump through, but just you can be. You can also be disciplined. It's also not protected if you actually engage in criminal conduct, like threats.
Oh, absolutely not.
Like if you make terroristic threats, you threaten to harm, injure, kill, or do something to somebody's property or person. That's not protected.
Absolutely.
They can call the police for that. Okay, they can get restraining orders for that.
Right.
Illegal conduct is not protected under 4515.
No.
Legal conduct. The only part we were getting tripped up on, and I'd probably have to take a look at it because we don't file a lot of these, is I can't remember if defamation to a private figure requires malice. I think only public figures.
I'd have to freshen up on that. And
I think
you're correct. We're not really pursuing these within the dynamic.
No, because of the anti-slap situation, because it's just too expensive to get over for the average person. But I'm 98% sure that only if you're seeking a claim for defamation on behalf of a public figure, you got to prove intent and malice. But if it's a private figure, you don't have to prove intent or malice. You just have to show that it was false and that there was damage. Okay. Now, in a case where, there is this blurry line about the difference between an opinion and a statement, a false statement.
Yeah.
We're not going to get into that either. That's not what this episode's about, is what's defamation. Maybe in the future one day, but today we're not talking about the elements of defamation. So let's get away from that. But, you can say things online that I believe, I've looked at some of our recent minutes, and I think that somebody's committing embezzlement on the board, or I think that our board is doing a terrible job managing our finances. The reserves are awkwardly low, or ridiculously low. And I think that there's some financial shenanigans or possible embezzlement. None of that's defamatory. That's all very opinion. You can say that stuff. They can't stop you.
That being said, I must say this, so I'm not remiss.
Say it.
When folks come to me in an advisory capacity, through RPCs and consultations, although that's true, I generally advise them to attempt to steer clear of attributing criminal conduct unless it's substantiated or can be substantiated.
That's always a good idea.
So the criticism is fine and healthy, and they can say, look, red flags, this doesn't add up on I've reviewed the financials, something's missing, there are major omissions, they're not providing adequate records so that I can reconcile this.
I see that.
Lack of transparency, but to go beyond and attribute, let's say, intentional fraud, which is a more heightened standard.
You better have something.
Exactly.
Okay. Yeah. So that is very good advice for a lawyer to give to a client or potential client, what we call PCs.
Right.
That's the lawyer advice. We say that to cover our butts, but we also say it because it's true.
And you don't want your client to lose credibility either.
But what I'm doing is informing as well. You can go further than that if you choose to. There is a difference between saying this person is a criminal, this person has committed fraud, and saying it looks like this person's committed fraud because things aren't adding up. There's a difference between those. One of them is protected. One of them might be actionable. Might be. Okay? But you're right. When we're speaking to other people, we should always be cautious and tell them that.
Right.
Because our job is to not get them right up to the line, to get them a little bit behind the line so that they don't approach that line.
Exactly.
And that's what you did, and I respect that, and I support that. But it goes further than that, right? We have a buffer, okay?
Right.
And that's what you're describing, and I totally get it. And I agree. I thank you for saying that, because that is important. The whole point, though, is when it comes to those provisions and governing documents, and lots of HOAs in different states have those provisions as well. We were actually interviewed, even though I'm not licensed in Florida, years ago. A Florida-based newspaper wanted an opinion from me about HOAs in general, having those provisions, and this was after the amendment to 4515. And so I explained that in California, at least, those provisions were void.
Yeah.
And of course, my article last month, I harshly criticized, without naming that attorney, who should know better, harshly criticized them.
And by the way, that attorney's opinion and what they published, and I'm trying to steer clear of saying too much, was post this amendment. So clearly, from a chronology standpoint,
it was only last week or 2 weeks ago.
Major omission over.
I'm sorry, 2 months or 2 weeks before, a month ago or 2 weeks before it was 2 weeks before I actually wrote that article.
Right.
It was in July.
Yeah.
Okay, so because I wrote it late mid-July, and that statement was made somewhere in the beginning of July. So this was 4 years after.
Well, that goes to show you that even a high-profile attorney at a major
Real estate
law firm that specializes in real estate, but is not really, their bread and butter and specialty is not within HOA law,
exactly.
Davis-Sterling Act.
And why you're getting bamboozled by hiring that, right? We've done an episode on how to pick an HOA lawyer. Just because you have a high-profile, expensive, north of $1,000 an hour lawyer who's got decades of real estate experience doesn't mean they know squat about the Davis-Sterling Act. I mean, that's why, for example, I recently gave an MCLE course at the Beverly Hills Bar Association, and it's online. Anybody can access it for a fee. You pay them. But I did the first ever course on basic laws under the Davis-Sterling Act, and kind of as a primer for real estate lawyers to advise clients on HOA-related stuff. And this thing was the most attended. I was told it was the most attended event they'd had in decades. And I had more questions than anybody else had ever had. So many that we had to stop early, and I had to take them by email over the next several weeks.
Oh, wow.
So even these are all experienced real estate lawyers practicing in LA area or Beverly Hills area who really had zero knowledge about the Davis-Sterling Act. Bottom line, folks, is 4515 is one of those statutes that is there for 100% protection of the homeowner and to basically pull back HOAs who made a history of going too far. If you like this episode, please hit the like button. If you haven't already done so, please subscribe to the channel HOA Hell. If you want to leave a comment, please do so. Until next time, have a wonderful day.